I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man.
Oh, do not even insult this court by saying that, Mr. Bennett. Do not. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No. Mike.
Court calls the case of the people versus Marquesi Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, except
All right, it's your motion.
caretaker for. So at the very least, the restriction on his phone privileges to contact me.
All right, well, before I hear from the people, counsel, let me just say, you came in here the first time, and, well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order.
I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel?
I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to support.
Go ahead.
I want to apologize. I don't think I'm being bad at all. is praying about my child. I can't say that I'm not in here for nothing. You know, obviously think I am. Yeah. I just want to apologize. Like I said, I'm not big that. I don't want to be here. I really don't. Truly. So, again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from what I understand, the PCC.
Yes, sir. He's all this.
This moment shows exactly what happens when a defendant underestimates the power of the court. The judge isn't just reacting emotionally. She's responding to repeated violations, including cutting off a tether and ignoring direct orders. In the legal system, compliance is everything. Once someone proves they won't follow rules, the court has very little reason to show leniency. What we're seeing here is a clear shift from giving chances to enforcing consequences.
Recovery complete.
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 9 a.m. in person before Judge Perry.
That's right. Court does call the case of the People versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with and I'm here. James Dennis Whitley.
This is People's emergency motion to modify bond in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client
Call her to show up to do what?
today to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
All right. Have you seen it? 14A District Court of County, Washington, session, the Honorable Judge J.
You may be seated. Court recalls the case of the People versus Whitley.
Assistant Prosecuting Attorney wants to so much on the table.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newton on behalf of Mr. Whitley, who's standing to my right. Will you state your name before, please? James Dennis Whitley.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court.
Why?
No, my turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. Happy. All right. They're bringing him.
Yes.
What stands out here is the defendant's attitude, openly admitting on recorded calls that nothing will stop him. That kind of mindset is exactly what hurts his case the most. Courts rely heavily on behavior, not just words. When someone continues to break rules even after being jailed, it signals a complete lack of respect for the law. The judge's strong response isn't personal, it's a reality check. Actions like these almost guarantee stricter decisions moving forward.